How likely are you to go to jail for a first-time DWI in Texas? We're going to find out right now. Howdy, I'm Brian Foley. I'm a board-certified criminal defense attorney in Conroe, and I represent people in the Conroe area, the Woodlands, Montgomery County, that area, as well as Houston and the surrounding counties. Today we're going to be talking about DWI, and specifically I'm going to answer the question, how likely is it that you're going to get jail time on a first DWI in the state of Texas? Well, I would say in general, the answer to that is not very likely. Now, there's a couple things that can be very misleading about the law that you might be wondering about, especially if you've read this statute. In Section 4904 of the Texas Penal Code, that is the law that outlaws driving while intoxicated. And it says that for first offenses, there's a minimum jail time of 72 hours in jail. That's true, that's in the law, if you have been sentenced to jail for your crime, right? So if you're found guilty, that's the first step. You'd have to be found guilty before jail time could potentially apply. And then after that, you'd have to have been denied any type of probation and been only given jail, right? So a lot of times counties will even try to waive this requirement. And so as long as the jail is calculating your jail time, a lot of times they give you 2-for-1 or even 3-for-1 credit. And courts will sometimes, even if you've been assessed 3 days in jail, give you the credit for the time you've already served. So, the bad news here is that for a DWI case to begin in the first place, you have to get arrested, you have to get booked in at the jail. 99 times out of 100, this happens after you were given field sobriety tests, maybe given a chance to do a breath or blood test. And then the officer arrests you and takes you to the jail right then. Now, sometimes somebody will get in a wreck, okay, and they'll take you to the hospital instead, maybe because you have injuries. Well, they're not going to arrest you if you need medical treatment, you need to go to the hospital. That means if they believe your DWI, that you were intoxicated while you were driving that day, what they'll do is apply for a warrant later on. And so you're still going to have to go to jail to turn yourself in on the warrant, but sometimes we can do what's called a walkthrough. You're going to be in jail a lot shorter period of time. If it's in Montgomery County, typically you're going to get what they call a Article 1517 hearing. It is a chance for the judge to read you your rights, your right to an attorney, and to explain what you're being charged with, and then determine whether there's probable cause for that case to get filed with the county courts. So at the end of the day, when you are looking at a DWI, you're trying to avoid jail time, the first thing your attorney wants to do is try to negotiate the deal with the prosecutor. The prosecutor is the person who works for the state, and they will determine what your offer is going to be. They have to agree with the offer in order to resolve the case. So if you want to get it dismissed, they've got to agree to dismiss it. The only other way to resolve a case, if you don't have an agreement from a prosecutor, is to win the case at a judge or a jury trial. And you don't really want to try that at first. You want to try to negotiate it out, because you never know what a judge or a jury is going to do, especially a jury, because they're more unpredictable. So let me go over what a prosecutor would be looking at if they were going to try to make you an offer of jail time on a DWI first. First, they would look at the severity of the DWI itself. Was there a crash? Did somebody get hurt? If somebody got serious bodily injury, meaning something that risked them dying, well, then they're probably not going to charge you with DWI first. They're probably going to charge you with intoxication assault. If somebody was killed, they'll charge you with intoxication manslaughter. So, but if there can be a crash, somebody gets injured, but they're not seriously injured, and that would be a regular DWI, but you could see a prosecutor trying to offer jail time under extreme circumstances like that. They're also going to look at the history of the defendant. Has this person ever been arrested before? Are there any prior DWI arrests that ended in a dismissal? The prosecutor will look at that prior DWI arrest, even if the reason it was dismissed was because they just couldn't prove the case. Maybe you were totally innocent. The prosecutor is probably going to assume that you just got away with it. They're going to hold it against you, and it could increase your likelihood of getting a jail offer. The other factor would be the political climate of the area where the DWI occurred. Did this prosecutor, who's the elected DA, just get elected because there was some type of news story, or has there been recent DWI arrests in that area that have involved death or serious bodily injury? That could influence how seriously they're going to take the case. Another factor is the attitude of the defendant, the person who's being charged with the crime. when they were dealing with the police? Were they abusive with their language? Did they use any racial slurs, profanity with the police, things like that? I've seen that increase an offer for somebody. But if you were polite and compliant and, generally not a problem for the officers, they're going to take that and look at it more favorably. And we will sometimes argue that with the prosecutor as to why we ought to get a better deal. Is there a policy in the office, the DA's office, about plea offers? A lot of different jurisdictions, the bigger they are, the more policies they're going to have. And that can definitely affect whether you're going to get an offer with some kind of jail time in it. But normally, if there's a policy about the offer and you're getting a policy offer, it won't be jail time for a DWI first. And then finally, did the police do things correctly? Did they violate any constitutional rights like the Fourth Amendment, the Fifth Amendment, and things like that? If they have some type of legal violation in their behavior, we can argue that as a reason why jail time should be taken off the table or the case ought to be dismissed entirely. I hope this has been helpful to you, and we will see you next time.